Hello, I'm Giles Watson from Queensland Law Society, and I'm here to talk to you today about the QLS Limitation of Liability scheme. Solicitors in Queensland will soon be able to cap their liability and cap their exposure to negligence claim damages under a new scheme. The QLS scheme, due to begin on 1st of July this year, will cap the occupational liability of participating QLS members at either $1.5 million or at $10 million, depending on the size of the practice. This is good news for QLS members. It should bring peace of mind and remove the need for most of top-up insurance. Firms will need to review their own arrangements, but the opportunity to cap their liability should be an attractive prospect for most practices. QLS has been working on this scheme for a number of years with the Professional Standards Council, an independent body that approves caps for different professional organisations. We've also been working with the Law Institute of Victoria and the Law Society of New South Wales in an attempt to create compatible schemes for national consistency. As part of the application process, Queensland Law Society had to demonstrate that its members were subject to rigorous requirements in relation to risk management, continuing professional development, discipline and auditing of trust accounts. I'm happy to say that the Professional Standards Council were happy with all of Queensland Law Society's arrangements, and therefore there will be no additional compliance burden for members as a result of the introduction of this new scheme. The scheme applies to full members of Queensland Law Society who have a current practicing certificate, current professional indemnity insurance, and who pay the $70 registration fee. The registration fee is for each individual member and covers a $50 registration fee which goes to the Professional Standards Council and $20 for Queensland Law Society to administer the scheme. It should be noted that the scheme is voluntary rather than mandatory, and members will have an opportunity to opt out of the scheme. In addition to members, the scheme also protects the employees of legal practices, provided that all the solicitors who can sign up to the scheme do so. The scheme therefore operates on a one-in, all-in basis. All solicitors within a practice have to be both members of the Queensland Law Society and members of the scheme to benefit from the cap. In terms of the detail of the scheme, detail is available in a QLS document called Limitation of Liability Scheme on the QLS website. In summary, however, the scheme acts to cap occupational liability at $1.5 million for participating members who at the relevant time of any act or omission were in a law practice of up to and including 20 principals and had a gross fee income of up to and including 10 million. The cap applies at 10 million for participating members who at the time of any act or omission were in a law practice of more than 20 principals or a practice which had a gross fee income of more than $10 million. There are, however, a number of areas of concern which members should be aware of before they sign up to the scheme or before they amend their top-up insurance arrangements. The first is that the cap doesn't apply to personal injury matters. This is due to the current drafting of the legislation, the Professional Standards Act 2004, which specifically exempts personal injury work from the focus of the cap. Queensland Law Society has written to the Queensland Attorney General seeking amendments to this legislation in this regard twice, but at the moment has not received a satisfactory response. The exemption on personal injury work therefore continues. Also exempted under current arrangements are incorporated legal practices as distinct entities. Individuals within ILPs will be protected under the cap, but ILPs as separate entities will not be. QLS is looking to amend their scheme and amend their membership categories to address this, but at the moment ILPs are still exempt. Another important issue is claims aggregation. The Lex on Insurance policy aggregates related claims in a number of areas so that they are recognised as one scheme. The scheme, however, to cap liability does not aggregate claims in the same way. This means that if a practice receives, for example, 5 claims on related issues, they may be aggregated by Lexon Insurance so that the member receives total insurance of only 2 million. If, however, each of these claims were of a value of 1 million, the capping scheme would not come into effect, but the total damages would exceed up to 5 million, for example. That means there will be a shortfall between the total damages and the insurance received, which the cap cannot address. Yet another issue is insurance exclusions. The Lexon Indemnity Insurance Scheme excludes insurance from certain issues such as client mortgage loans or employment liability. If members receive claims in these areas, the cap again will not apply. A final issue to consider is claims-made insurance versus the occurrence-based nature of the scheme. Lexon acts to provide insurance for when claims are made, whereas the scheme acts to limit liability based on when an act or omission occurs. This means that firms may wish to consider extending their top-up insurance for a number of years to cover acts or omissions which occurred when the scheme was not in place. On all these issues, please consult the QLS guidance, which is on the QLS website. The scheme will commence on the 1st of July 2010, and there will be an opportunity to sign up for the scheme through the annual QLS renewals process. As I mentioned earlier, the scheme cost for each individual member will be $70. You're encouraged to discuss with your colleagues whether this suits your personal circumstances, and also look at your top-up insurance arrangements to discuss whether the scheme gives the total protection that your practice needs. The scheme does not claim to offer total protection against claims, but does significantly reduce the risk of damages above the compulsory level. It provides certainty for members on their liability and should be a key component of any practice's risk management strategy. Thank you.